Hi, my name is Alex Dolphin. Welcome back to another episode of Exante, and today we're going to discuss the case of MacPherson versus Buick. This case was heard in the New York Court of Appeals in the year of 1916. For a bit more context, the New York Court of Appeals is truly the New York State Supreme Court. Let's go ahead and jump into the facts of the case. Donald MacPherson purchased a Buick in New York and began driving it. While he was driving, one of the wheels on his vehicle collapsed, which caused him to be thrown from his vehicle. MacPherson sustained serious injuries and brought suit against Buick, claiming that Buick was negligent in not inspecting the wheel before they placed it on the car. Buick defended themselves, saying that there was nothing inherently dangerous about a vehicle and that they shouldn't also be liable because they didn't in fact manufacture the wheel. It was bought from a third party. And they argued that if anyone was to be held liable, it should be the third party manufacturer of the wheel, not themselves. So the issue in this case is whether Buick, the manufacturer, can be held liable for damage caused by a part of their product that they didn't indeed manufacture. The wheel wasn't manufactured by Buick, so can they be held liable for the damages caused to a plaintiff because of the result of that wheel, even if they didn't manufacture it, they simply put it on their product. Judge Cardoza, a very famous judge in the realm of torts, ruled in this case, and he ruled in favor of MacPherson, claiming that Buick had a duty to inspect all the parts that were placed on their vehicle to ensure safety for the driver in the future. Judge Cardoza further wrote, if the nature of a thing is such that it is reasonably certain to place life and limb in peril when negligently made, it is then a thing of danger. So he extended the principle of torts in recovery to a more broad class of products that are dangerous or could be dangerous when operating them. It allowed plaintiffs in the future to recover based upon damages done to them by operating those products. He furthermore said that the manufacturer has a duty to inspect all parts carefully in their finished product. All right, so now that we have the ruling down, let's go ahead and jump into some of the ex ante implications. The first one being the most obvious, in that this ruling and the precedent that comes from it does just pass the buck of liability from one manufacturer to another, and ultimately places the liability on the end manufacturer. Now, this is probably done to promote efficiency in the courts rather than a plaintiff having to go to multiple manufacturers to seek relief. They're able to just seek relief through the final manufacturer. And I think that was the purpose of the ruling, is that it was very efficient as far as allowing the plaintiff to recover directly from Buick. There might be some problems with that. It does seem to give these, the wheel manufacturer and other analogous companies sort of an ability to get out of any type of liability just by not being the final producer of the product. So that's a little bit concerning. It might not incentivize the wheel manufacturer to do its fair share of inspections before it sends it to Buick, because they're not liable ultimately for any damages that are done to the driver of the vehicle. Definitely something to think about there, and the incentives for inspections and safety inspections that will come in the future because of the precedent set in this case. I want to just expand a little bit with a couple of metaphors. First being a car mechanic. So I want to envision a scenario where precedent in this case might be applied to a car mechanic replacing a transmission in a vehicle. Well, if the transmission is faulty, and after the car mechanic fixes the transmission in your car with a new one, and that new transmission blows up and causes you an accident in the future, could the plaintiff, underneath the precedent of MacPherson versus Buick, hold the mechanic responsible for and liable for the damages done to him because of a malfunctioning transmission? Seems to me that because the mechanic was the final manufacturer of the product, he could be held liable for any damages done to a plaintiff. Don't think that makes a whole lot of intuitive sense, because truly the transmission company was responsible for the damages done to the individual. Something to think about there. Also, envision a home where a home builder goes ahead and builds a brand new home for an individual and installs a faulty water heater. If that water heater were to explode, it would allow that plaintiff to just sue the home builder rather than to have to sue that water heater manufacturer. I think that's something to think about a little bit. Just like I said earlier, the incentives of a manufacturer to inspect their product are a little bit diminished when they're basically granted immunity from suit because they're not the one who put the final rubber stamp on the product. Buick in the case of MacPherson versus Buick, a home builder in the case of the water heater, or a mechanic in the case of a replacement car part. Something to think about. Also, is important to note the efficiency that does come as a result of this ruling. It allows plaintiffs to recover directly from the final manufacturer, and I think that was definitely on Judge Cardozo's mind when he was making this ruling, is the principle of efficiency in the courts. It allowed plaintiffs to recover more expeditiously against the defendants for wrongs that had been done to them, rather than having to go through 12 different hoops to find the final manufacturer of that specific part. So thanks for watching. I hope you have a nice day. Let me know if you have any other ex ante implications. Leave them in the comments below. Bye.